Our story begins in Congo, a town in Angola scarred by one of Africa's longest civil wars. In the image, Ignacio and his family. They are not fleeing drought, flood, or failed harvest. The province of Angola where they currently live is quite fertile. They are among the victims of the country's 27-year civil war, forced to move from their home territory by the terms of the negotiated ceasefire. Like the half-million people facing starvation in Angola, they are the victims of a man-made disaster in a country that should be teeming with oil and diamond wealth. Most of the internally displaced settle around the capital in musek or mud houses in the countryside. Angola has a serious humanitarian crisis. A cause of the prolonged war, the abundance of minefields, the continued political and military activities, but most of all, the depredation of the country's rich mineral resources by the regime. The year is 2007. Traditional construction techniques are wattle and dab walls and thatched roofs. There's virtually no electricity in smaller rural villages, and running water is intermittent or unavailable in many areas. Angola has a tropical climate with a distinct wet and dry season. The area around Luanda, and particularly by the south of the capital, sees the least rainfall. When it downpours, the melted mud plasters and debris are abandoned, and new houses are built in cleaner proximate area. But this is not the case. This time, Ignacio and his family were forced to leave, since the landlord claimed the land for development. That landlord in Angola is the state, identifying what De Soto calls the potential energy in assets. Assets that up until now served immediate physical purposes, houses used for shelter, parcels of land being sowed and harvested. And as the new brick technology arrived to Waku Congo, permanent houses were built by the state for retired officers. Soon after, in 2008, Angola signed an agreement with an Israeli developer to build the New Age village. These brand new houses were demolished to introduce a new model, Aldea Nova, a new village using the Israeli Moshav model of private smallholder agricultural and joint services, drawing ex-fighters, former soldiers who were receiving government pensions, creating a rental market and capital for mortgage. But this is not the story about the wealth and politics nexus of weapons, oil, and mega communication infrastructure projects. My project was driven by the concern for more than 400,000 Angolan refugees living in camps and settlements, lacking a permanent address, a concern for Ignacio and his family and their destiny, unable to rely on the government who displaced them in the first place. Several international declarations, covenants, and interpretations recognize housing as a human right. The International Covenant on Social, Economic, and Cultural Rights recognizes the right of everyone to an adequate standard of living for himself and his family, including adequate food, clothing, and housing, and to the continuous improvement of living conditions. This is the right to live somewhere in security, peace, and dignity. Requires adequate privacy, adequate space, adequate security, adequate lighting and ventilation, adequate basic infrastructure, and adequate location with regard to the work and basic facilities, all at a reasonable cost. Parties to this covenant must ensure security of tenure and that access is free of discrimination, and progressive work to eliminate homelessness. Forced evictions, defined as the permanent or temporary removal against the will of individuals, family, or communities from the homes and land which they occupy, without the provision of and access to appropriate forms of legal or other protection, are a prima facie violation of the covenant. In 1991, a general comment to the International Covenant on Social, Economic, and Cultural Rights interpreted the right to adequate housing, breaking it into several components, acknowledging that housing is a compound term. But looking at the national level, we know that the practice of the recognition of housing as a right existed in national constitutions since earlier times. And so, in the year 2010, Angola legislated its new national constitution, introducing clauses that establish the protection of access to housing to the young, economic protection and living conditions for the elder, and a specific article directed towards every citizen's right to housing and quality of life. In an effort to define what the right to housing is, the pioneer Michelman defines it as a claim upon organized society on behalf of each individual or household unit to assured access to minimally adequate housing. He does make a distinction between the right to housing and the right to be housed. According to UN representatives, the right to housing shall not be taken to imply that the state is required to build housing for the entire population, or that housing should be distributed for free to everyone, or that the state must fulfill all aspects of this right immediately upon legislation, or that the state should entrust itself or unregulated markets to ensure housing. Certainly, it does not mean that the right to housing will manifest in the same manner in all geographic locations. Now, according to Michelman, the right to housing exists based on three principal arguments or normative systems. The first is philosophical ethics, based on a universal need of shelter manifested in all the animal kingdom, where the lack of housing could mean an existential risk. The second argument is social justice, conducing to market correctives, based on the principles of equality and social minimum for decent living. And the third argument is law. A right to housing that is explicitly stated in legislation should be respected as part of the contract between the people and the state. So what conceptions of housing rights and state obligations are reflected in the text of national constitutions around the world? I focus in constitutions because this is the most basic law of the territory out of which all other laws emanate. The Constitution establishes the rights of individual citizens. A constitutional right to housing is a freedom granted by the government's constitution at the national or subnational level that may not be legally denied by the same government. For this purpose, I gathered the entire set of currently valid national constitutions, retrieving the relevant clauses and analyzing them across 50 different criteria. Constitutional housing rights clauses may appear in a variety of forms. This is a published classification between indirect clauses, for example, property rights, and embedded and direct rights that explicitly mention housing, within embedded, for example, as part of workers' rights or directly as a right to housing. For our purpose, we chose the two first groups, the direct and embedded tiers. Once sorted, the 133 clauses were grouped into 7 different categories. The first recognizes housing as a right. The second protects housing from abuse and deprivation. The third group are clauses empowering private persons to defend their homes. The fourth group establishes a duty of the state to create a housing plan or a housing policy or a housing fund. The fifth group establishes a duty of the state to provide the means to achieve housing by supplementing private initiative. The sixth group establishes a duty of the state to provide housing or distribute public estates, social housing, for example. And the seventh and last group obliges the state to assure the access of housing by minorities and dependent people to housing. Having sorted constitutional housing right clauses, an obvious question was, why do some countries do have them, while others don't? We look at several variables to understand this phenomenon. One of them is the Gini coefficient, asking whether social gaps could explain the existence of these rights. We did not find a strong correlation. Neither did we find a relation to the HDI, Human Development Index. We found both developed and developing countries with constitutional housing right clauses. A possible explaining variable was the legal system. We looked at civil, common, and mixed law systems, finding out that common law systems do not present any kind of constitutional housing rights. Also, the practice of releasing full-fledged constitutions is not embedded in common law countries. As for the contents, and the following slides show the different scales, the different range of wording found within this constitutional clauses. This slide shows the split between negative rights or protections and positive rights or provisions. And we can see how the language changes from protecting to empowering to assuring access, recognizing housing as a right, establishing duties to create mechanisms, providing the means, or providing housing itself as a positive right. The following slides show the range of findings among entitlement, eligibility, and responsibility criteria. Here we see the various categories ranging from ownership to rooflessness. So the most common category found among constitutions was actually reference to social public housing, found in 36% of the cases. But the cases range among title and registry through housing ownership or rental housing, communal possession and cooperative housing, through caregiving institutions, protections of tenants against unreasonable rent increases or rent control, protection from deprivation, protection from forced eviction, informal settlements or squatters. There is also a reference to nomadism, resettlement of displaced populations, and homelessness. The latter were achieved the lowest scores. Eligibility is particularly interesting. In a paper, I attempted to provide an index which brings together the categories of eligibility with a global perspective. Eligibility depends to a great extent on the country in which the claim is made, with a wide variation among countries in the standards to establish which populations are entitled to housing assistance or determining who is in need. It is reasonable to attempt to identify those national constitutions according to which it is easiest to qualify to housing assistance, as well as those where housing rights are too vague, for example, those who are silent. It is possible to compare the stringency of the eligibility provisions to determine the extent of inequality. It is also possible to quantify the myriad of ill-defined eligibility standards. So based on Fiskia, a sociologist that studies stereotypes, I found an ambivalence in stereotype content and the actual eligibility categories protected by constitutions. There is also a claim that civic stratification helps achieve greater social control, maintaining and justifying inequality. So here, for example, we may question why some countries give eligibility to everyone while others entitle only citizens, or perhaps more exclusive groups like family or workers, youth and elder, as we saw in Angola, disabled, indigenous groups, the poor, those in need, inadequately housed people, or gender-based. As of responsibility to implement or provide the entitlements, findings show a strong acceptance among countries that housing, including plans, are the responsibility of national authority. Local authorities are given little consideration, about 9%, although their role in housing provision and social integration is crucial. And a small 6% and 5% are either responsibility of the private sector or shared responsibility with citizens. The Constitution of Guatemala, for example, delegates some responsibility to owners of enterprises in cases established by law. They are obliged to make available to their workers housing units that meet certain requirements. The same clause was found in several other Latin American states like Brazil, El Salvador, Honduras, Mexico. and Uruguay. And there are also silent clauses, about 13%, that either leave the responsibility unclear or to be further defined by law. So from a general glimpse, and this may be not at all surprising, if we look at the three different scales, the entitlement, eligibility, and responsibility, the red squares represent the highest concentration of constitutions. There are some global trends of what is widely accepted within the constitutions as far as housing concerns. So in entitlement, we will usually see the adoption of measures or policy without extensive explanations. Then further in eligibility, usually the entitlements are given to citizens. And the responsibility, it is widely accepted that it is state responsibility to provide the right to housing. Another aspect that deserves attention is the use of adjectives that reflect a certain vagueness. For example, by using terminology such as decent housing or adequate or proper or suitable according to need, sufficient living accommodation, these adjectives reflect a certain need to further interpret what this terminology means. Another subject that deserves attention is the vagueness used through adjectives in the different clauses, for example, by using the word decent, the word adequate, the word proper, suitable, according to need, or sufficient. These are all adjectives that are quite unclear and need further interpretation. To conclude, although the right to housing had been defined in terms of accessibility and was not meant to imply housing delivery, de facto, the majority of constitutional housing rights are positive rights that grant provisions. Another conclusion is that legal culture is the strongest explaining variable to the existence or lack of constitutional housing rights. Similarities and the genealogy suggest that most constitutional housing rights have been borrowed from one constitution to another, and therefore we find similarities that I did not discuss between, for example, the Angolan, the Portuguese, and the Brazilian constitutions. Did the 2010 Constitution of Angola introduce a change? Well, the answer is very limited. In the year 2020, the state remains a significant holder of the housing stock, although it has ceased to be a major supplier of new housing in the Angolan market. Only 9,101 units were released to the market in the past year. Most of these were constructed by Chinese, Israeli, and Portuguese firms, and some of them were left incomplete when the credit lines ran out. So the housing shortage actually persists. So what do we conclude about constitutions and constitutional clauses? Well, in many of the cases, these are more of a visionary documents than actual codes of practice. Constitutions, according to Feiner, are like door locks. These are clearly unnecessary to honest people who pass the door and equally are useless against the determined burglar. But they can and they do deter the casual strollers who might otherwise come in and help themselves. Thank you very much.